against Chief Constable of Thames Valley Police.
Mr. Mayor.
My Lord, just very quickly, Lord Burrows yesterday asked for two things. One was the Bagshot article, which I hope you've now got. I don't know. Oh, it was sent to the registry this morning. So that is now available. But we also have, fortunately, I have the first edition of this famous book, which I have to say is now Fairgrieve and Booth. Sorry, no, Fairgrieve and Squires. Not the second edition, this is the first one. We haven't had time to copy the pages. If you want, was it 161 to 163 you wanted?
It's the reference made in that article, so if they are the pages, then yes, please.
So whatever cross-references from the Bagshot article to this one?
No, from the to Forest and Steel.
All right, well, we'll check that up. And
thank you very much.
But would it be possible to get the court to make the copies? Because otherwise, we do it in chambers, it's going to take time. That's the only thing. I mean, we can do that, we can get somebody to come down.
Lord Hodge.
I don't suppose we're in a hurry, are we?
No.
I'm probably not in a hurry for it.
No, there's no great hurry.
There's no hurry.
I mean, I understand it is not the policy of the court now to photocopy things. So if it's made available as and when.
Okay.
Thank you very much. The other point I would raise is you raised with the court by email the question of the reply time. Yeah. The court accepts that we did start late. Apparently it was a...
We might not need it.
Monty, but you will have your 30 minutes if you need it.
If you could give us that extra 10. Well, if we need it.
Well, that's what I'm saying. I said, I told you you had lost 10 minutes, but you will have your 30 minutes if you need it.
Yeah, thank you.
Good morning.
Yes, Mr. Mornick.
Yesterday, my Lord Burrows asked for the reference in the evidence about the attempt to flag down the van. It's at page E222. If we could just
page
E22 to 222. 222.
That's Mr. Kendall's witness statement.
Mr. Kendall's witness statement for these proceedings. Yeah. And it's at paragraph 9. He says, as I was stood at the side of the road, I saw a van approaching the same stretch where I had just crashed. I actively tried to signal to the driver by vigorously waving my arms around, despite being in pain, but he either did not see me from my position on the side of the road or decided not to stop as it was still very dark, and there would likely have been no visible sign of my car in the ditch. And then at paragraph 10, he says, as soon as the van passed by, I decided to ring the police. I could not decide whether to dial 999, and so decided for some reason to dial 101 instead. I explained to the controller the facts of my accident and that my back and chest were hurting and that I had tried to flag the van down, but it had failed to stop. A few other vehicles passed by whilst I was on this call, but I didn't try and flag them down as I was engaged on the phone.
And that is the evidence, the sum of the evidence?
That's the sum of the evidence.
Thank you.
And I think he says that the police arrived just as he finished the call. He finished the call in the police.
Yes.
When you look at the actual log, he didn't even explain to the controller.
No, and
he tried to flag the van down.
No, he didn't. But for the purposes, because it's a strikeout and because it's been alleged in the particulars of claim that he did, we felt constrained to accept that. Turning to our case to develop the legal submissions I make, our written case on page 97, core bundle, paragraphs 15 and 16 of our written case. And at paragraph 15, I'll just read the first sentence because this is what the duty is said to hinge on or arise from. And it's the appellant's case hinges on the fact that the police attended an earlier accident involving Mr. Kendall It is said that the fact of their attendance was sufficient to create a duty to later users of the highway, because had they not attended, Mr. Kendall would have remained in situ and would have attempted to warn the later motorists of the ice. And our submission, and that, which I will make good, I'm not going to go to all of the authorities because of the time constraints, I'll concentrate on a few of them, but the submissions we make are summed up in paragraph 16. Which is that, contrary to the appellant's case, it's clear from the authorities that but for or counterfactual causation is not by itself sufficient for the creation of the duty of care. Something more is required. And to have come under a duty or a liability, a defendant must have performed an act which was in itself wrongful, or have undertaken an activity which carried an inherent risk of harm which would not otherwise have existed, or assumed a responsibility to the claimant to protect them from the harm in question. And we say the appellant's argument that Mr. Kendall or others might have been able to protect Mr. Tindall from the accident had the police not attended is an argument of potential relevance to causation if a duty of care was owed and breached, but it doesn't.
Isn't your point a rather simpler one than those contentions there, which seem rather dubious to me, actually, whether the act itself has to be wrongful, but your point is that the risk created has to be a reasonably foreseeable risk.
Yes. Yeah, there does have to be a reasonably foreseeable risk. But what the authorities show is that not just because you've done a positive act, or even in some cases where you have done a positive act with a foreseeable risk, such as Mitchell, for example, Mitchell and Glasgow, that doesn't actually in itself always establish a duty of care. So reasonable foreseeability is an important ingredient which we say is missing here. It's not always the end of the story.
Yes, one can look at it, whether you're analysing it as an exception to an emissions rule, or you're saying you're outside the emissions rule altogether. You are saying, as I understand it, that in order to give rise to a duty of care on the police, it must have been reasonably foreseeable that they were displacing a rescuer.
Yes, well, they must have done something which explains that they come under a duty. It might be a way of putting it colloquially.
But yes, well, their presence, I think what's being said is their presence displaced a rescuer.
Yes.
Yeah. And you're saying, as I understand it, that there's absolutely nothing in the evidence to suggest that they had or could reasonably have identified Mr. Kendall as performing that role.
Yes, I do say that.
I think that is the non-point of that paragraph, really.
I mean, on the facts, they did displace or rescuer, but and they did create a risk by leaving the scene, but that wasn't one that was reasonably foreseeable if they had no reason to know that that's what they were doing. Yes,
it wasn't. But what I do submit, while taking out to the authorities as well, is that it would be a pretty rare case where attendance by a public authority or presence at the scene by a public authority in itself establishes a duty. It may be that in a certain case it could be supplied if there was the additional ingredients, but there must be something more than mere attendance or presence.
But displacing a rescuer could be something more, couldn't it? Suppose Mr. Kendall had been there clearly warning motorists when they arrived, they realised that and sent him off to the hospital, then they would be knowingly creating a risk if they just drove off and left the scene worse than when they arrived.
Yeah, you're not going to like me for this, but I'm not going to fully accept that proposition because, as we say in paragraph 38 of our case, even had he been warning and the police arrived, which isn't the facts, I would still submit there would have to be some sort of assumption of responsibility. Because let's take the case where it's, for instance, a passing motorist, or even say the RAC or something, who come to rescue him. And if Mr. Kendall, and everybody accepts Mr. Kendall doesn't owe a duty to continue doing what he's doing, how can it be that the person who, without any discussion with him or agreement with him, just because they replace him, suddenly comes under a greater duty that they have to stay for some indefinite period? So I do submit that here there is something that even on those facts there would be something more required to create the requisite.
Well, why aren't they simply acting in a way that creates an unreasonable risk by dispatching him and not replacing him with anything else?
Particularly in circumstances where they're the emergency services who've arrived on the scene to deal with the scene, and it's predictable and therefore foreseeable that anybody else who might have been warning at the scene would leave because they'd otherwise be obstructed.
The answer to your point may be Mr. Kendall may not have been under a duty to stay, but if he had, and on the evidence he hadn't, if he had indicated to them that it was his intention to stay till sunrise or until the ice melted, and they then replaced him, that is a slightly different circumstance from what you're postulating, it seems to me.
Well, I think if the facts were those, that he'd said to them that he was going to stay until sunrise, or that was his plan, or he would have done that, and then another rescuer took over, then that would be coming close, I would accept, to an assumption of responsibility. But in relation
I don't see assumption of responsibility has anything to do with it, though, because that's a principle that applies as against the claimant. And nothing that's going on here is an assumption of responsibility towards the claimant.
No, I mean, but I accept that there are examples in the case law where, for instance, Kent and Griffiths, the assumption is to the claimant, but the promise is made to the doctor and the claimant's husband, I think it was in that case, or wife, I can't remember.
But if the acid test or an acid test for whether exceptionally someone who comes on the scene to help rescue incurs a duty of care is whether he makes matters worse, if you come on the scene where somebody is performing a rescue activity and you knowingly take over from him in that exercise, and then you go off-site, if you look at your conduct as a whole, from when you came onto the scene until you left it, is it not reasonably foreseeable that you have left matters worse overall because you came on the scene where there was a rescue activity going on, and by the time you left it, there wasn't?
Well, perhaps
the case here being about ice, not about the car in the ditch.
No.
And nobody suggests that the ice was any less icy at the end of the process than it was at the beginning of it.
I suppose it's that postulation which gives me my hesitation about reasonable foreseeability being enough, because it's to make matters worse, and this is where our submissions on the law do come in. You have to have done something which is carried out some sort of activity or act which itself is inherently risky.
But isn't coming on the scene, seeing an in situ rescuer there, that rescuer leaving and you not replacing that warning system, that is making matters worse seen holistically?
I can't push this any further, but I still submit that there's a gap in the question that, because one has to look at what's the duty, but as my Lord Burrows put it in the HXA, one always has to ask what's the duty that's been assumed, as my Lord Legate, Lord Legate and Lord Hodge put it in the case about the scope of duty KMNX.
That was Lord Sales.
Yes.
Lord Sales and I.
Sorry, Lord Sales, and yeah, I'm sorry. That you always, one always has to look at what's been said, that the duty is. So, here we have, they turn up to assist Mr. Kendall. They're the rescuers of Mr. Kendall. But what the appellant seeks to create out of that is a duty to others. And in response to my lady's point about, well, the rescue service, the police, the problem with that submission is just like similarly with the fire brigade, is the fire brigade, and there's a sort of general expectation and hope that the fire brigade will put out fires. There's a general expectation that the police will perform their functions. But that argument collapses into the fact that they are a public authority with powers is not sufficient to create a duty, because one has to always test whether the duty would have been owed by a private person.
Yes, I mean, I don't think any of the points that have been put to you depend on the police being a public authority with certain public duties. The points would make equal sense if it's a rescuer on a beach.
Well, if we take then, for instance, supposing it was the RAC or the AA who turned up at this accident, and they have their signs that they can put out while they're helping the driver who's stranded. Why, I ask rhetorically, would they have come under a duty on these facts to stay once they saw Mr. Kendall go off in the ambulance?
Can I put this question to you? Let's assume that we're trying to tease out what has been called the interference principle, which I think is an aspect of being worse off. Now, you're, I think, challenging, even if it would be enough, if the police had causally been responsible for Mr. Kendall leaving the scene. But you're also, I think, saying that you need some sort of knowledge or constructive knowledge by the police that he was actually carrying out warning.
That he was engaged in a rescue operation.
Now let's assume that that is the point that is troubling us. Are you then saying that we have to strike out because there is no prospect of, at a trial, that question of knowledge being, if you like, sorted out on the appellant's behalf in a way that they could establish that the police knew or ought to have known? Are you saying even at its highest, there's nothing that gives them that right to go to trial?
I am, because we've got the particulars of claim which put the appellant's case at its highest. But more than that, in this case, we have a particulars of claim which have been pleaded against the background of an inquest which lasted many weeks, and the summary findings are set out in the statement of facts and issues. And we...
Can I just be absolutely clear in my own mind? The particulars of claim that we've got now, have they been, their amended version, are they?
I think they're the only version. Actually, I think I was wrong when I suggested amended yesterday. I think I made
right, but they have, they've been put forward after all the inquests and everything. Yes,
they have. And of course, since then, we made the application for summary judgment, which then led to the statement from Mr. Kendall, being produced. So we are seeing this case has been fully investigated. And if the appellant had a case of this nature, it really ought to have been pleaded.
Well, even apart from the pleading, which may not have caught up with all the evidence, we can look at the whole material and say that there isn't anything there. Yeah.
There's no real prospect of success.
So paragraph 10 that you took us to of the witness statement of Mr. Kendall at 222.
Yes.
I explained to the controller the facts of the accident that my back and chest were hurting, that I tried to flag the van down, but that it failed to stop. You're saying, as I understand it, that that does not in any sense indicate that the police knew or ought to have known that Mr. Kendall was acting as a warning.
Yes.
Let alone that he was planning to continue to do that after they came and an ambulance.
So if I just follow this through, if we're trying to work out the interference principle, I don't think we're going to get it from any case law. But what we are going to say is that McBride and Bagshaw seem to have done the fullest job, as I understand it, in articulating what that principle might be. Am I to understand that you're saying that one crucial element for your case, for the appellant's case, is that the police did not know or ought to have known, applying the Bagshaw and McBride principle, that just cannot be established in this case?
Yes.
Yes, but I think in your discussion this morning, you're going further.
Yes, I am going further. I may not need to.
Yes,
but,
you're saying even if you can pocket that, and even if that is sufficient, you've got a further line of defence.
Can I just add to that? Not only do we not get from this evidence at its highest that this was someone who was engaging in an ongoing rescue operation or warning system. We also have the facts that when the officers turn up, they see a man who's put down on a stretcher and taken off in an ambulance.
So your presentation of the facts, and you say this is the highest that the appellants can put them, is Mr. Kendall was just a victim of a road accident as far as the police knew or could reasonably have known.
Yes.
There's nothing that gets him into their knowledge area of warning other vehicles. Thank you.
Can I turn briefly to capitals and counties? Capital and counties at tab 11, it's electronic bundle 294. And I take it the court is probably very familiar with the facts. But can I just highlight a few passages from it? Firstly, at page 317B of the bundle, so I should say this is under a heading at 316. Is there a common law duty on the fire brigade to answer calls to fires or to take reasonable care to do so? That's what the court is considering in this section. And at 317B, reference is made to a submission by counsel for the claimants about the doctrine of general reliance, which was that the public generally rely on the public authorities to exercise their statutory powers, which have been granted, and or a duty to respond to the public's help. And he referred to Sutherland Shire Council in Hayman from Australia, which at that stage, the Australian High Court looked like it was going to develop the doctrine of general reliance. There will be cases, this is according to Mason J., in which the plaintiff's reasonable reliance will arise out of general dependence on an authority's performance of its function with due care, without the need for contributing conduct on the part of the defendant or action to his detriment on the part of the plaintiff. Reliance or dependence in this sense is in the general product of the grant and exercise of powers designed to prevent or minimise the risk of personal injury or disability, recognised by the legislator as being of such magnitude or complexity that individuals cannot or may not take adequate steps for their own protection. this situation generates on one side, the individual, a general expectation that the power will be exercised, and on the other side of the authority, a realization that there is a general reliance or dependence on its exercise of the power. And then examples of air traffic control and firefighting are given. And Lord Justice Murray Stuart Smith says the principle of general reliance has been applied on a number of occasions in Australia, and he refers to a couple of cases. And I should say, Your Lordships, I'll not take you to it, but in the bundle there's an article by Professor Nolan, and the reference, I'll give it to you, is a E1255, because he says that the High Court of Australia have since abandoned the doctrine. Lord Justice Stuart Smith says that the doctrine has received little, if any, support in English law. There appears to be no case except the Anne's case itself, which could be said to be an example of its application. And two of the examples suggested by Mason J have been held not to give rise to a duty of care. Mark Rich and Co., a classification society in which a vessel was entered, was held not to be under a duty of care to cargo owners in respect of a negligent inspection of the vessel, and a similar conclusion was reached by the Court of Appeal in Philcox and Civil Aviation Authority. The authority being held to be under no duty of care to the owner of an aircraft alleged to have been negligently inspected and improperly given a certificate of airworthiness. And further, in a passage in his speech, which is admittedly obiter, but was apropos Mason Jay's reference to the principle in the Shire-Sutherland case, Lord Hoffman in Stoven's case said, the general application of the doctrine of general reliance may require some very careful analysis of the role which the expected exercise of the statutory power plays in community behaviour. For example, in one sense, it is true that the fire brigade is there to protect people in situations in which they could not be expected to be able to protect themselves. On the other hand, they can and do protect themselves by insurance against the risk of fire. It is not obvious that there should be a right to compensation from a negligent fire authority, which will ordinarily inure by right of subrogation to an insurance company. The only reason would be to provide a general deterrent against inefficiency, but there must be better ways of doing this than by compensating insurance companies out of public funds. And while premiums no doubt do take account of the existence of the fire brigade and the likelihood that they will arrive swiftly upon a scene, it is not clear that they would be very different merely because no compensation was paid in the rare cases in which the fire authority negligently failed to perform its duty. Although the Plaintiffs' Counsel have criticised Lord Hoffman's reference to the existence of insurance as being an invalid ground for saying that it is not just fair and reasonable to impose a duty of care, we do not think that this is what Lord Hoffman is saying in this passage. Rather, he is suggesting that there is not a general expectation that fires will necessarily be extinguished by the fire brigade. There is no doubt a hope that they will be, but they may arrive too late, to be of no practical use, or they may not arrive at all. Instead, for the most part, people rely upon insurance for indemnification in case of loss. And then
That's not very convincing reasoning, because of course people don't expect that the fire will necessarily be extinguished, but they might expect that reasonable efforts will be made. So, anyway, with
the point I take from it is, and the point I submit from it is that this idea that because the public expect, or as it's put, hope the performance will be done, that's not enough to give rise to a duty. If one's going to look for a duty...
Mr. Kendall's private assumption that the police will...
Yes, but I don't... I understand the appellants are accepting the equality principle.
Exactly. We're not reinventing that.
So this general reliance doctrine, it would be totally inconsistent with the equality principle.
Well, yes, it would. Yes. I mention it because it does go to the fact that all that we have in Mr. Kendall's case, looking in what's in his mind now, is an expectation that the police will do their job. So this distinguishes the case from, and no doubt is why my learned friends have correctly abandoned assumption of responsibility as an argument, because assumption of responsibility involves a specific undertaking with specific reliance, which we don't have on the agreed facts because the police didn't say or do anything to Mr. Kendall.
It could still be relevant to the factual position, it seems to me, if it might be relevant as to whether, as a matter of fact, Mr. Kendall would have been likely to stay or not, the people who turned up were the police.
Well, it might be relevant to the issue of causation, I suppose.
Yeah.
Yes.
But the assumption of responsibility, we don't have to consider it, but it wouldn't be an assumption to Mr. Kendall.
No, that's one of the difficulties with the appellant's argument, and that's why we've referred in our case to cases like Sandar, which again, actually, for your Lordship's notes, considers this distinction between a general expectation. Well, perhaps I should just briefly go to the passage.
Just before, do forgive me, just before Mr. Warnock answers, could I just ask you, please, to keep your voices up? Because I'm having really quite some difficulty catching everything, particularly, my Lord Hodge, your voice is dropping a little. I'm sorry, the lack of the loop. I don't want to make a big thing about this, but I'm really trying to follow all of the interchanges. But I'm struggling just a little bit, as you can probably see by my constant bobbing up and down, for which I apologise.
If I could just briefly divert from this. Sorry, I'm sorry, hope you can hear me.
No, I can hear you. That's why we moved. I
hope I'm not shouting either.
Yeah, okay.
But if I could briefly divert from this authority to the Sandar case, at page 1647 of the bundle, E1647.
Just before you get there, when you say the appellants have abandoned the assumption of responsibility argument,
there isn't a page 1647.
There isn't what, sir?
There is no page 1647.
It runs off the end at 1531.
I'm sorry, I don't know what. It's 943. I'm sorry, that's my fault. I don't know.
943?
Yes.
Thank you.
when you say they've abandoned that, were they running a full-scale assumption of responsibility in the Court of Appeal?
Yes. That's what the case was all about, as they ran it in the Court of Appeal. First of all, it's not all about that. It was about making things worse as well.
Okay.
And then it was assumption of responsibility and control.
Right. And you say that that's gone except as a sort of aspect of the control argument still, and maybe status?
Yes, I wasn't sure if it was still there as part of control and status.
Right. I suppose it depends what you mean by assumption of responsibility,
yes.
But an assumption of responsibility to Mr. Tindall in the sense of some sort of contact between them is, on the face of it, a complete non-starter.
Yes.
Yeah.
And what we say in the control bit is because Lord Toulson correctly identified the two aspects to the control, one a special relationship with the claimant, one a special relationship with the person, or in this case, the thing that's being controlled. But we have all the cases on the highway liability, but I'll come back to that. Can I just say, paragraph 46, Lord Justice May says the view which he's expressed, and I think that's the view about needing specific and assumption of responsibility and reliance. He says the view I've expressed is generally consonant with the law relating to rescue organisations. See, for instance, Capital and Counties and OLL and Secretary of State for Transport. And he then sets out the facts of the Capital and Counties case. And then at letter C, he says in OLL, the same principle was extended to the Coast Guard conducting rescue operations at sea. As in the present appeal, the claimant relied on an internal manual and orders intended and designed to ensure that the Coast Guard discharged its responsibilities properly, efficiently and effectively. As in the present appeal, it was said that the Coast Guard had encouraged an expectation in the minds of the public that they would respond promptly and appropriately to marine emergencies. It had thereby assumed responsibilities to the public for the execution of search and rescue missions in coastal waters. It was submitted that a duty of care arose from the expectation that the Coast Guard would act carefully, the expectation being created by ministerial pronouncements, published procedures, and a common knowledge that the Coast Guard would act when it knows of an emergency at sea. In rejecting these submissions, I considered that they strained what Lord Hoffman had said in Stoven and Wise beyond breaking point, and I read a passage in the judgment of Stuart Smith LJ, which is as saying that, in effect, that in English law no duty of care arises from a general expectation. I further considered that this particular duty derived from a specific expectation publicly induced, and relied on that a lighthouse authority will not withdraw an existing light without giving due notice. An example discussed by Lord Hoffman was very different from a general duty on the Coast Guard to conduct any search and rescue operations it may undertake without negligence. If I could go back to capital and counties at page 321 of the bundle, 321. And the argument in capital and counties in the Hampshire case, which was the turning off the sprinklers case, and was being put on two different bases. The first basis was sort of Caparo and Dickman's analysis, where the key issue the Court of Appeal held was proximity. And the second basic alternative ground was assumption of responsibility. And at 321 letter D, Lord Justice Stuart Smith said, we turn to consider the first of these submissions, in other words, the proximity Caparo analysis. The peculiarity of fire brigades, together with other rescue services, such as ambulance or coastal service and protective services, such as the police, is that they do not, as a rule, create the danger which causes injury to the plaintiff or loss to his property. For the most part, they act in the context of a danger already created and damage already caused, whether by the forces of nature or by the acts of some third party, or even of the plaintiff himself, and whether those acts are criminal, negligent, or non-culpable. But where the rescue protective service itself, by negligence, creates the danger which caused the plaintiff's injury, there is no doubt in our judgment the plaintiff can recover. There are many examples of this. Rigby and Chief Constable of Northamptonshire. The plaintiff's gun shop was at risk from a lunatic. The police came to deal with the situation. They fired a CS canister of gas into the shop, though it caused a high risk of fire, without ensuring that the fire engine, which had previously been available, was there to put out any fire that resulted. In Knightley and Johns, in the course of a traffic control following an accident, 2 police constables were instructed to take a course which involved them riding against the traffic flow around a blind bend, causing a collision in which the plaintiff was injured. And then Dorset Yacht, the defendant's prison officers had brought the Borstal boys, who had a known propensity to escape, into the locality where the yachts were moored, and so had created a potential situation of danger for the owners of yachts, in which they failed to exercise proper supervision over the boys. Similarly, in Alcock and the Chief Constable of South Yorkshire, where the question and issue was the liability of the police to those suffering shock as a result of the Hillsborough disaster, there was never any dispute that the police were liable to the primary victims because they had created the danger by incompetent crowd control. These are all cases, however, where a new or different danger has been created from that which the police were seeking to guard against, except perhaps the Alcock case. A comparable situation would be if on arrival at the scene of a fire, the fire engine was negligently driven into the owner's car parked in the street. But it seems to us that there is no difference in principle if by some positive negligent act the rescue protective service substantially increases the risk. He is thereby creating a fresh danger, albeit of the same kind or of the same nature, namely the fire. The judge held that at the time the sprinklers were turned off, the fire was being contained, but once they were turned off, it rapidly went out of control, spreading in blocks B and C, which had been deprived of their sprinkler protection. And then at E324, His Lordship considered a causation submission, and this is the bit my learned friend relies on. But what I submit here is that this was a causation argument being made, the duty and breach having been established. And it's at letter B. Mr. Mumby also relied upon the judge's finding, or rather lack of finding, as to what would have happened if the fire brigade had not turned up at all. The judge had said he was unable to say whether or not, on the balance of probabilities, if the fire brigade had done nothing and the sprinklers had been left on, the building would have been burned down completely. Mr. Mumby submitted the absence of a positive finding. The plaintiff's case must fail, since the burden of proof rests on the plaintiff to show all necessary elements for recovery. We do not accept Mr. Mumby's submission. The danger with fire is that unless it can be controlled and prevented from spreading at a relatively early stage, it will quickly become out of control and consume all in its path. That danger was particularly acute having regard to the construction of the roof at the Crescent. Having negligently turned off the sprinklers which at that stage were containing the fire, the defendants, by their positive act, exacerbated the fire so that it rapidly spread. The question is thus one of causation and has to be tested with the benefit of hindsight by comparing what would have happened if the sprinklers had been left on with what in fact happened. So what I submit is that what the court is not saying there is that causation which established the duty. The court found that there was a duty and breach, and then that raised the issue of causation.
So what's your explanation for the distinction between what's being said in that case and our facts, in particular in what was said at page 321 with the first paragraph that you read out to us? Perhaps if I just sort of summarise it, it might be said that the police on our facts have negligently increased the risk of the ice.
Yeah. What I submit is when one goes back to the pleading and was back to what this case is about, the only the thing that's said to have increased the risk on the pleading is the fact that the police attended. That's it. And it's not alleged that their attendance was negligent.
No, it's not. It's the whole of their activity. It's the attendance and then they're leaving.
Yeah. But
obviously by attending the risk, they couldn't possibly create a risk.
No.
But by displacing the protection that was available, this is their case in Mr. Kendall, and not replacing it with anything, that creates a risk.
But that comes back to my submission about what type of act is necessary to make one under a duty to protect from an omission later, because the examples that my learned friend took the court to yesterday in Clark and Linsell, where you set off for your drive, not perfectly reasonably, not knowing anything's wrong with your car, and the car breaks down on the journey, you can't just abandon it in the middle of the road because you've left something dangerous in the middle of the road. But in that case, one is undertaking an activity in a situation where the law recognises that it's right that you should bear the risk attendant on that activity. One is driving a car out on the highway.
But isn't the principle there, you've created a risk, not itself not by acting negligently, but you have by your act of driving created a risk, and in those circumstances, being aware of that risk that you've created, you owe a duty of care to try to prevent it causing harm to others.
Well, I would submit not, because the activity that's been undertaken here is a rescue of Mr. Kendall. And
well, that characterisation of it begs the question. The activity is coming to the scene of an accident.
Yes, but in the context that Mr. Kendall's called them for help.
Well, I have ringing in my ears the comment made on the call log that it was obvious even to the person on the end of the telephone that if nothing was done, a very similar accident might occur thereafter if it was all caused by black ice.
Yes, but
in other words, you're not just looking at cleaning up the consequences of accident number one, but guarding against the consequences of its repetition before dawn.
Well, I think if one looks at the call log, in fact, that, again, that comment was made in the context of a worry about something hitting him, which is a point he averts to in his statement as well.
I mean, the negligence of the police was the starting point here. It was gross negligence.
But
the question is whether they owed a duty or not in the activity that they carried out.
Knowledge of a risk, of course, does not, on the authorities, create a duty. The fact that one knows somebody's about to walk over the edge of the cliff, or that somebody one's about, a third party's about to do something, does not in itself create a duty.
If it did, we wouldn't be here.
Doesn't it come back to much the same as the same argument, in a sense, that was posed under the interference principle? At one level, one can say that the police have causally increased the risk by having the effect of removing or displacing Mr. Kendall. But I think your answer previously has been that that is not in itself sufficient, because the police would have to know or have constructive knowledge or reasonably foresee that they were increasing that risk, and that here we've just got that factual lacuna.
It's instructive to compare, I submit, to compare the facts of this case to the facts of the Hampshire case. Because what grounded the liability in the Hampshire case was that there were sprinklers which were putting out the fire in the passage we've just looked at. The police come in, they actively turn them off in a way which is negligent. That's what the court says, as a result of which that fire is exacerbated. What we submit is that every single element of that formation is missing in this case.
Well, it would seem to me crucial that in that case, the firefighters knew, or ought to have known, that the sprinklers were controlling the fire to some extent. That would just be blatantly obvious. So whether you class it as a positive act or not, seems to me less crucial than the degree of knowledge. And the degree of knowledge appears, on your submissions, to be missing in this case.
Yes.
I think you also want to say that the police didn't cause Mr. Kendall to leave the scene.
No, they didn't. They didn't turn him off, as it were. The comparable fact here would be if it's as if the sprinklers just turned themselves off because somebody arrived on the scene. He turned himself off, as it were. He decided to leave. And can I just finish in capital and counties? I'm very conscious of the time.
Yes.
We've cited this passage at, in our case, but at page 326D. It was argued, just as it's been argued here, that the fact that it's an offence, essentially, to interfere with a fire officer who's carrying out an operation. This is at letter D. Plaintiffs' counsel argued that the provisions of section 33 and 2, which confer on the senior fire brigade officer present sole charge and control of firefighting operations and make it a criminal offence willfully to obstruct or interfere with any member of a fire brigade engaged in firefighting, establish a proximate relationship once responsibility for fighting the fire is taken over by the brigade. This argument has its attraction, particularly in the somewhat extreme facts of the Hampshire case. As Mr. Slater pointed out, the plaintiffs had two systems of fighting fire, one very effective in the form of automatic sprinklers, the other the manual firefighting capability of their employees. Station Officer Mitchell rendered the first ineffectual and ordered out of the building the plaintiff's employees who were attempting to attack the fire. But it seems to us that the statute imposes control of operations on the senior officer for the benefit of the public generally, where there may be conflicting interests. By taking such control, that officer is not to be seen as undertaking a voluntary assumption of responsibility to the owner of the premises on fire, whether or not the latter is in fact reliant upon it.
I mean, here the significance relied on for the duty is different. They're not making the assumption of responsibility argument. They're using it in response to your lack of causation argument. They say it's totally unreal that for the police to say they didn't cause Mr. Kendall to leave the scene when he would have been committing an offence, as they would know, if he'd tried to interfere. Well, it wasn't just some voluntary choice that he made unpredictably to wander off. It was a direct result of their turning up with all the blue lights flashing.
Well, the argument came up in the context of an assumption of responsibility argument, in this case, capital and counties. But it's clearly in front of an experienced Court of Appeal. It would be surprising if they somehow missed that this argument might somehow be relevant to the creation of a duty somewhere else.
Well, it wasn't relevant in this case because they weren't displacing somebody else.
Well, they did, in fact,
The question didn't arise here.
Well, it did, in fact, because it says that at paragraph E,
plaintiff's employees.
The plaintiff's employees were busy putting out the fire and he displaced them.
All right, but there's not an argument, was there, that if they hadn't done that, those people would have succeeded in putting out the fire?
Well, I think there was implicitly in the causation argument that was run.
And we better let you develop your submission. So what are you asking us to take out of capital and counties?
Well, what one takes from capital and counties is, first of all, that to have created a danger, one has to have committed a positive negligent act. Secondly, mere attendance or presence at a rescue scene or an emergency scene does not generate a duty of care, nor does ineffectual intervention at that scene generate a duty of care, nor does the fact that members of the public might hope that the public authority will do its job properly and it generate a duty of care. Those are the propositions I take from this case.
Thank you.
Could I turn to Mitchell, which is at tab 8, bundle page 741. This was a case, my lords may recall, about two tenants who, one of them was a problem tenant who was causing problems for Mr. Mitchell. And there had been various attempts by their landlord, the Glasgow City Council, over a number of months to try and manage it. And we know from the facts of the case, even looking at the head note, letter E, in January 2001, the local authority had served a notice for proceedings on D, who was to be the murderer, which provoked him into yet more threats against M. And at that stage, the local authority was keeping M informed of the steps it was taking in relation to D. But in July of 2001, without informing M, the authority summons D to a meeting at which he was warned that continued antisocial behaviour could result in his eviction from home. And about an hour after leaving the meeting, D attacked M with such violence that M sustained injuries from which he subsequently died. And the case, when it reached the House of Lords, was all about whether or not there had been a duty to warn M about the fact that the local authority was going to have this meeting, which on the facts provoked D into attacking him, and the House of Lords overturning the Court of Inner Session, sorry, the Inner House of the Court of Session, held that there was no duty. I'm not going to dwell on Lord Hope's speech because he analysed the case first and foremost in terms of Caparo, although it is worth noting that he did specifically associate himself with Lord Reed's dissenting judgment in the Inner House. But could I ask the court to turn to Lord Scott's speech at page 760. And at paragraph 40 on page 760, he said the requisite additional feature that transforms, he'd set out the parable of the Good Samaritan just before that, but he said the requisite additional feature that transforms what would otherwise be a mere omission, breach at most of a moral obligation, into a breach of a legal duty to take reasonable steps to safeguard or to try to safeguard the person in question from harm or injury, which may take a wide variety of forms. Sometimes the additional feature may be found in the manner in which the victim came to be at risk of harm or injury. If a defendant has played some causative part in the train of events that have led to the risk of injury, a duty to take reasonable steps to avert or lessen the risk may arise. Sometimes the additional feature may be found in the relationship between the victim and the defendant, e.g. employee, employer, child, parent, or in the relationship between the defendant and the place where the risk arises, e.g. the fire on the defendant's land in Goldman and Hargreaves. Sometimes the additional feature may be found in the assumption by the defendant of responsibility for the person at risk of injury, see Smith and Littlewoods, per Lord Gough. In each case where particular circumstances are relied on as constituting the requisite additional feature alleged to be sufficient to cast upon the defendant to take steps that, if taken, would or might have avoided or lessened the injury to the victim, the question for the court will be whether the circumstances were indeed sufficient for that purpose, or whether the case remains one of mere omission. And he then says there are two features in this case. The first I'll not dwell on, that was the fact that they were, there was a relationship of landlord and tenant. But second, at paragraph 42, second, it was what was said at the 31st of July meeting by the local authority officials to Drummond that apparently provoked him into inflicting on Mr. Mitchell the fatal assault. Was this causative link enough, or arguably enough, to cast upon the local authority a delictual duty of care to take steps to protect Mr. Mitchell? This, to my mind, is the critical question that arises on this appeal. And he then considered the facts of a South African case about a company which sent a boat out, boat working when it was sent out, but then broke down when it was out, and the company did nothing to rescue the employees or the people it had on the boat. Unsurprisingly, a duty was held to arise in relation to that activity. And at paragraph 44, on page 762 of the bundle, letter B, he said the council's comparable, there seems to be no equivalent, that is, to the effects of that case in the present case to those features. The council's comparable obligation to Mr. Mitchell was to act as a responsible landlord and to take steps to terminate Mr. Drummond's tenancy in order to remove him from the locality where he was causing trouble. That obligation cannot, in my opinion, suffice to justify treating the local authority as having assumed responsibility for Mr. Mitchell's safety. The local authority did not have any delictual duty to protect him against assaults from Mr. Drummond that those steps might possibly provoke. And he goes on to say, I can agree it would have been prudent to have given the warning, but it does not follow a failure to have done so can be represented as a breach of a delictual duty of care, nor can the local authority's omission to have warned the police be so represented. He sets out that the relationship can't give rise to it. And then he says at the end of that paragraph that he agrees that his reasons are no more than supplemental to the reasons given by Lord Hope, but also those given by Lord Roger and Lord Brown. And Lord Roger at 762 of the bundle, his speech begins, at 762, and he, at paragraph 55 said, paragraph 55 on page 764, he said, so on the afternoon of the 31st of July 2001, the local authority officials were taking a step towards doing what the local authority were empowered to do under section 47 and what Mr Mitchell wanted the local authority to do. Later that afternoon, Drummond assaulted Mr Mitchell. On behalf of the local authority, Mr Smith argued the pursuers were seeking to make the local authority liable for omission, for failing to warn Mr Mitchell, and of course that is right. But the position of the local authority is not exactly comparable to, say, someone watching and doing nothing as a child drowns in a shallow pool or a blind man walks into the path of an oncoming car. In such cases, the observer plays no part in the events. Here, however, what the local authority officials told Drummond undoubtedly led on to his assault on Mr Mitchell, and then he sets out the analysis of, according to the analysis and terminology of art and honoré causation in the law, by telling Drummond at the meeting that the local authority were going to issue a fresh notice of proceedings. The officials provided an opportunity for Drummond to assault Mr Mitchell. It might be preferable to say what the officials did was provided a particular reason why, foreseeably, Drummond might choose to assault him, or to adopt the expression used by Lord Sumner in Blundell and Stevens. What they did can be seen as giving an occasion for Drummond's attack. The question is therefore whether the law should impose a duty of care on the officials when fixing such a meeting to warn someone of Mr Mitchell's position and give him an opportunity to take avoiding action. And then at paragraph 57, he said, on the bottom of page 765.
That formulation in paragraph 55 seems to be more logical than Lord Scott's formulation that it's all a matter of causation, because it's how you characterise the causation.
Yes.
By reference to the duty of care.
Yes, I would agree with that.
Yeah.
And at paragraph 57, he says, as Lord Gough explained, in some circumstances, a defender who provides an opportunity for a third party to harm the pursuer in a foreseeable way must take reasonable care to prevent the harm. If I negligently collide with a cyclist who is knocked unconscious, I must surely take reasonable care to move her from the path of oncoming vehicles. Whether I must also take reasonable care to prevent her belongings from being stolen may be more debatable. Similarly, a decorator who leaves the door of an empty house unlocked is indeed liable if a thief then enters and steals, because the main point, at least, of the decorator's duty to lock the premises is to prevent theft, Stansby and Troman. A police authority owes a duty of care to the public at large, not to entrust a gun to a probationer officer whose family circumstances might make him volatile and unstable. So the authority was liable to someone whom the officer shot in the course of an incident when he was intent on using the gun to maim his former partner and her boyfriend, Attorney General of the British Virgin Islands in Hartwell. In all these situations, the defendant's acts, which provides the opportunity, which provides the opportunity for the third party to injure the claimant, is itself wrongful. As Lord Summer pointed out in the passage from Blundell and Stevens, quoted by Lord Gough, that is not enough to make for liability and delict for the harm which a third party subsequently deliberately chooses to inflict, but it is at least a start. In the present case, by contrast, not only were the local authority officials not committing any wrong by holding the meeting with Drummond, they were taking steps towards exercising a statutory power given to the local authority as landlords to be used in the interests of good order in the neighbourhood of the houses. It was these entirely lawful and legitimate steps which provided the occasion. No delictual duty can arise out of these steps as such. Baroness Hale, at paragraph 76 on page, just forgive me, page E771. Said the second point upon which we were all agreed is that foreseeability alone is not enough to impose a duty to safeguard a person from criminal acts of third parties. It is a necessary but not a sufficient condition. There must be something more. Lord Roger of Earlsferry in paragraph 57, which is one of the paragraphs we've just looked at, and Lord Brown of Eton under Haywood in paragraph 82 of their opinions have given some examples, none of which applies in this case. In essence, there must be some particular reason why X should be held to have assumed the responsibility of protecting Y from harm caused by the criminal acts of Z. And I also share the view of Lord Roger in paragraph 55 that this is not a pure omission case. A driver who takes to the roads and thus as an actor in the drama is liable for the things he fails to do as well as the things he does. His failure to keep a proper lookout or to indicate when he proposes to change direction is an omission, but he took the action of propelling his car in a particular way. Thus it could be said that the local authority were actors in this drama. They took the action of summoning Mr. Drummond to warn him of what they had proposed to do if he did not mend his ways, just as the driver should not change direction without taking steps to safeguard other road users from harm. It could be said the local authority should not take action against one tenant without taking steps to safeguard his neighbours from harm. Hence, it's not quite enough to say that complaints of failure to warn is a complaint of pure omission, but the question remains whether it's fair, just and reasonable to impose such a duty. And then Lord Brown, at paragraph 85, said that he had nothing to add to what had been said by Lord Hope and Lord Roger. And we also, in our case, refer to what Lord Reed's...
In 85, he was talking about the human rights claim.
Was he? I'm so sorry if I have misled inadvertently.
Yeah.
I'm sorry. Yes, you're right. I'm sorry. We've also referred in our case to what Lord Reed said in the court of, in the Inner House, and we have that's at 1193 of the bundle. And at paragraph 121, he had said, although the pursuer's argument was not presented in this way, it might be argued that when the defenders responded to the reports of the incident on the 10th of July, they undertook an activity which carried an inherent risk to Mr. Mitchell's safety at the hands of Drummond, and that they therefore owed Mr. Mitchell a duty of care to protect him from that risk, under reference to Lord Hoffman's observation in Gorringe that reasonable foreseeability of injury is insufficient to justify the imposition of liability upon someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it. It might be argued that the defenders did not do nothing. They acted in response to the reports and by doing so created the risk to Mr. Mitchell's safety and therefore owed him a duty of care to protect him from that risk. On examination, this argument has built into it an assumption that the defenders owed Mr. Mitchell the duty of care in question. In other words, it assumes what it bears to prove. In the passage just cited, Lord Hoffman was adverting to the distinction between liability for acts which attaches to a person who creates the risk, and for omissions, which attaches to the person who undertakes to do anything to avert it. In order for a person's act to be regarded as creating a foreseeable risk of injury, there must be what the law would regard as a causal relationship between the act and the injury which is likely to occur. In the example given by Lord Hoffman in Environment Agency and Express Car Company Limited, in the passage cited earlier, the factory owner who left out the drum containing highly inflammable vapour did not do nothing, but neither did he create the risk that the drum might be ignited by an arsonist. As Lord Hoffman said in Stoven and Rise, in another passage cited earlier, and I think we're all familiar with that, but he goes on to say, Lord Reid goes on to say, having said that passage from Stoven and Rise, to hold the defendant liable for an act rather than an omission, it is therefore necessary to be able to say, according to common sense principles of causation, that the damage was caused by something which the defendant did. Common sense principles of causation are not independent of notions of duty, as was explained in the Express Cargo case. Whether one considers that, according to common sense principles of causation, Mitchell's death was caused by the defender's actions depends on whether one considers that the defenders breached a duty to take precautions against the risk that Mr. Mitchell would be assaulted by Drummond. The legal question whether the defenders owed Mr. Mitchell such a duty cannot, therefore, be answered by considering, as a matter of common sense, whether the defender's actions created the risk to his safety. The question has to be addressed by considering the principles established by the existing law. And he then sets out how investigating a complaint about someone is a very common activity. And at paragraph 129, E1195, paragraph 129, he sets out his conclusion. He says the more fundamental question is why any legal obligation should have been imposed on the defenders in informing Drummond that they intended to serve a fresh notice, that they would continue to monitor any complaints, and that continuing antisocial behaviour could result in his eviction. They were not undertaking an inherently dangerous activity. The next case...
What are you taking from?
Well, what I take from this case are 2 points. One, it is not as simple as my learned friends say, that you can say that simply because the defendant had some causal involvement in what happened, that a duty of care arises. That would be flatly contrary to what the House of Lords held in Mitchell. And secondly, I tie it into the overall submission I make, which is that to come under a duty, the defendant must have done something which was a positive act or action which itself was wrongful or inherently risky. And what we submit is there is nothing inherently risky about an emergency service carrying out, well, there is obviously to the people who work for it, but there's nothing inherently risky in an emergency service conducting the activity of rescuing a motorist from the road, which can generate the duty of care alleged in this case. The last case I want to go to on the creation of danger point is actually a case that was decided before Mitchell, but it was in the High Court. We saw reference to it by the Court of Appeal in Sandar. And that's OLL in Hampshire at 840 of the bundle. My lords and lady may recall that this was a very tragic case where a party of school children on an activities trip had got lost at sea when canoeing, and there was a search and rescue operation undertaken by the Coast Guard, who were later alleged to have failed to respond promptly and to have miscoordinated the rescue attempts of others, to the extent it was said that they gave the manager of the challenge centre misplaced assurance about where the party was likely to be, misdirected a lifeboat to search inshore rather than offshore and in the wrong area, and misdirected a Royal Navy helicopter and failed to mobilise another helicopter until it was too late. And the case was decided by Mr. Justice May, who struck the claim out. And the holdings summarised in the head note, he held there was no obvious distinction between the fire brigade responding to a fire where lives were at risk and a Coast Guard responding to an emergency at sea. And on that basis, the Coast Guard were under no enforceable private law duty to respond to an emergency call, nor if they did respond would they be liable if their response was negligent, unless their negligence amounted to a positive act which directly caused greater injury than would have occurred if they had not intervened at all. Moreover, the Coast Guard did not owe any duty of care in cases where they misdirected other rescuers outside their own service. It followed that the statement of claim in the instant case pleaded a cause of action which was bound in law to fail. And at 850 of the bundle, 850,
Sorry,
850, 850. His Lordship said, letter H in 850, I consider therefore that the Capital and Counties decision is to be applied to the Coast Guard. The remaining question is whether Mr. Stewart-Smith is correct in submitting that misdirections given by the Coast Guard to other rescue organisations are to be equated with the fire officer negligently ordering the sprinkler system to be turned off. In my judgment, they are not. Mr. Stewart-Smith accepts that if the Capital and Counties case is to be applied, no duty of care arises if the Coast Guard misdirect their own rescuing people or equipment, just as there would be no liability if a fire brigade misdirected its own fire engine. In my view, a distinction which would render the Coast Guard potentially liable if they gave misdirections to other people which do not result in positive injury directly inflicted is quite artificial. If there were two helicopters, one belonging to the Coast Guard and the other to the Royal Navy, it would be nonsensical if the Coast Guard were to be liable for misdirections given to one but not the other. Nor am I persuaded that you can sensibly impose liability by assessing a level of intervention which falls short of intervention, which results in positive injury directly inflicted. Further, the clear dividing line adopted in the Capital and Counties case, which goes back to a time earlier than the East Suffolk case, is crossed where a defendant directly inflicts physical injury. Directly inflicted physical injury is the first building block of the law of negligence, because unless it is excused, it will almost always be a component of a breach of duty. Misdirecting other rescuers does not of itself inflict direct physical injury, any more so than misdirecting the Coast Guard's own services, and is not alleged to have done so in this case. And OLL and indeed Capital and Counties were both considered by this court in the Michael case by Lord Toulson. And if we could go to page 710 of the bundle, at paragraph 79, he summarises the case, and at the bottom of letter H, he says, in striking out the claims, the judge applied the reasoning in Capital and Counties. He rejected the argument that the misdirection of searchers was analogous to the fire brigade turning off the sprinkler system in the Hampshire case, because it did not positively increase the danger to the canoeists. It was similar to a fire brigade sending one of its fire engines to the wrong address. And at paragraph 80, he says, in the Van Col and Smith cases, Lord Bingham reserved his opinion about the correctness of capital and counties and disapproved OLL, but he was alone in criticising them, and he did so in the context of formulating his liability principle, which the other members of the House of Lords rejected.
The idea that the rescue services have to be treated as if they were one seems to me a bit questionable.
Well, it seems to me there are two features to the case. That was one part of the judge's reasoning, for sure. The other part of the judge's reasoning, also mentioned here by Lord Toulson, is that they didn't actually positively increase the danger to the canoeists. And it may be that there is a distinction between stopping and in progress rescue, such as the sprinklers putting out the fire, and a case which merely alleges a lost occasion. That something, if you hadn't done something, then, or if you hadn't misdirected them, then there's a lost occasion that they would have got there. It's less direct, and I say that's true of this case too. Although we're actually stronger than OLL, because in this case, it's not alleged that the police gave any direction to Mr. Kendall, but it would seem quite extraordinary if the police had directed Mr. Kendall to go home or to go and stand and wave down traffic at the wrong part of the road, that they wouldn't have any liability, whereas when they give no direction at all, it's alleged that they do. I've mentioned in our case, I'm not going to go to it, we've put in the reference to K versus MNX, which is the scope of duty case. We've given the wrong reference, I think, to the paragraph in our case. We've said at paragraph 35 of our case, which is on page 105, we've referred to paragraph 30 of that judgment. Paragraph 30 is relevant, but paragraph 37 of KMNX is the point where my Lord Hodge and Lord Sales make the point that the scope of duty analysis can be of great assistance in analysing a case where it's been alleged that a person has assumed a duty to act in a case involving an omission, or come under a duty in relation to an omission. Perhaps we should just look at what was said. It's at page 613. And the relevant passage is at page 628 of the bundle. And at paragraph 36, my lords said what is often called the Samco principle, or the scope of duty principle, is that a defendant is not liable in damages in respect of losses of a kind which fall outside the scope of the duty of care. That's at 36, first sentence. And then at paragraph 37, my lords said the scope of duty principle may also be of analytical value and of central importance in other circumstances, such as where a claimant seeks to establish liability arising from a defendant's omissions. One example is when the court is considering whether a defendant owed a duty to prevent injury or damage to a person or a property of a claimant which has been caused by a third party. See, for example, Smith and Littlewood and Mitchell and Glasgow and Michael. And what we do point out here, it's very much, we think, of a piece with my Lord Burroughs, along with Lord Stevens' question in HXA, when looking at a duty that's said to arise by relation to assumption of responsibility, that it always sharpens the analysis to ask what is the duty that's being alleged. And here, the duty being alleged, as we say, is that because the police attended and dealt with Mr. Kendall's accident, out of that the appellant seeks to construct a duty of scope beyond any assistance provided to Mr. Kendall to protect him.
You seem to be addressing now the abandoned assumption of responsibility argument.
Well, maybe in part, but I do submit this analysis is helpful generally in relation to the question of whether there's a duty of care and omissions, or for whether the case ultimately comes down to you failed to protect someone from something. Then we've summarised, we've also identified in our case, should I make clear, passages from the other authorities, including East Suffolk, where we've highlighted passages which support our submission we submit in relation to there's been something more than mere causation being required. Can I just say we rely, of course, on everything in our case. I don't have time orally to go through it all. But in our case at paragraphs, page 106, E106, we make our submissions on the application of these principles to our case. And we say that in the present case, the police did not commit any positive act which was negligent or inherently created a risk of harm. Their attendance was not negligent. Having their blue lights on, using their police slow sign was not negligent. They didn't, by word or deed, encourage, direct, or coerce Mr. Kendall. And we've also made the earlier point relevant to the knowledge point at paragraph 15, where we've said it's not even alleged that Mr. Kendall was taking any action to warn traffic when the officers arrived at the scene. And we, if the fact that the police turn up and the mere fact that there is somebody else who was present, and this is true for any emergency service, might have done something had they not, or would have done something had they not, if that is enough to create a liability, then that is going to be a very wide expansion of liability, because in very many cases where the emergency services attend, there will be members of the public present. And no doubt, with appropriate searches, one will always be able to find someone who would have been a good citizen and intervened had the emergency services not attended. And I do reiterate the submission I made yesterday, although in this case, the only claimant here is Mrs. Tindall, a bit like Lord Hoffman averted to in relation to the position with the fire service. In many of these cases, the claimant will not necessarily be the injured claimant, because in many cases people slip on ice, which is partly their fault and partly the fault that the ice is there. And of course, local authorities have a clear statutory private law duty to keep the road clear from free and ice, subject to their Section 58 defence. But also, so they will have an interest in such arguments, but also so will motorists and their insurers. But we submit that on analysis, the argument just doesn't stand up. And we further submit on the particular facts of this case, taken at their highest, even if there was something in that argument, it doesn't apply or get the claimant home here. What I propose to do, I've got a little bit of time left. I'm going to let my learned friend, Miss Davis, make the submissions in relation to the so-called prevent interference exception, insofar as they've not been covered by what I've already said. She anticipates she'll be very brief. And then I'll finish with a few submissions on the control exception.
Thank you, Mr. Warnock. Miss Davis.
My lords, my lady, I will indeed be brief because much of the material has been covered. But we say that, with respect, this ground adds nothing to ground 1. The so-called interference principle is simply a form of making matters worse, and it therefore does not assist the appellant as a freestanding exception if they are unsuccessful in relation to ground 1 and making matters worse. I appreciate the court will not have had the opportunity to consider the material that was at that footnote 117 to the Defaris and Steele article, but I submit that that material, again, does not cite any English authority that was decided on that basis and decided by the judge deciding it on that basis. There's a further article by Professor Steele in this bundle at page 1332. 1332.
Thank you.
A 2019 article. In the introduction towards the bottom of that page, he lists various exceptions to the rule that a person is generally under no tortious duty to provide positive assistance to a stranger in peril. But he does not mention this exception. He mentions the various exceptions to the rule as being, for instance, where a person has assumed a responsibility to act, is in a special relationship with the person injured, or has failed to alleviate a source of risk that they have created. And his conclusion is at page 1346. In the second paragraph at that page, he summarises the argument that he set out previously and says that in the second part of that article, in the second paragraph there, argued that the law enjoys a large measure of overall coherence in the sense that the currently recognised exceptions to the general rule, assumption of responsibility, control, creation of risk and special relationships can all be understood as consistent with the normative underpinnings of the general rule. So Defaris and Steele and those two articles offer no explanation as to how, if at all, the prevent exception they identified in the 2016 article differs from making matters worse. We say, of course, that it doesn't. The appellants rely also on a case note by Nicholas McBride that the court was taken to yesterday at page 1287, and the conclusions to that are at page 1290, which I invite the court to turn to now. Under the heading Comments, his reasons for arguing that the Court of Appeal in this case were wrong in their decision are in the second paragraph. And it's argued that this was a case that should have been allowed to proceed to determine whether the interference principle applied. That principle, of course, is taken from his own book, the passages of which are in this bundle. And that book, in turn, cites various cases which we say are not analogous and were not decided on this basis. He then, in the last paragraph, asks why did Lord Justice Stuart Smith miss this point in an otherwise impeccable summation of the law post-Michael. Pausing there, we would of course say that Lord Justice Stuart Smith was such an impeccable summation of the law. But he then answers his own question. The reason may be that the idea that the interference exception to the rule against liability for omissions does not get a huge amount of attention and is sometimes completely disregarded. For example, in Michael itself, Lord Tilson only listed two well-recognised types of situation in which the common law may impose liability for a careless omission at 98. And those two situations were where the defendant was in control over a danger to the claimant and where the defendant assumed a responsibility to the claimant to protect the claimant from harm. As a ground for finding that a defendant owed a claimant a duty of care to protect them from harm, interference was completely overlooked. And we say that's consistent with the fact that it's not a ground that has been cited in the English cases and certainly not been the reason on which those cases have been determined.
Can I just take you to the second paragraph that you referred us to? What Nicholas McBride is there talking about is the idea that this should have been allowed to go to full trial in order to ascertain whether the principle that is there set out is made out or not. As I understand your submission, that would be inappropriate because even if we accept the McBride principle, at its highest, the facts can never establish that A knew or ought to have known that he's done something to put off or prevent someone helping B.
Yes.
Is that correct?
Yes, for the reasons given this morning, we'd say that constructive knowledge is not made out.
So this is an example of Nicholas McBride taking what you might say, with respect to him, is a rather loose application of what the law is on striking out, when you can strike out and when you can't.
It may be, and in fairness to him, it's a short paragraph, but, my lord, yes.
Well, he might not have studied the facts in great detail that we've been taking
Yes. Yeah.
It's more likely.
Turning very briefly to the case law, we would say that the cases cited by McBride in his book and cited by the appellants before this court as being cases that could be explained by the interference principle were not analysed in that way by the judges who decided them, and the facts are not analogous. I don't propose to take your lordships to the cases for reasons of time. I commend paragraph 52 of our written case at page 111 to your lordships, and we rely upon that. I should say very briefly at paragraph 52b, in relation to the case of Costello, it's my fault, but there's an incorrect citation, and the relevant passage of Lord Justice May's reasoning in Costello can be found, for your lordship's note, at page 379 of the bundle, an internal page of that authority, 767E to H.
Sorry, so it's not 553F and 564F, is that what you're saying?
It is, because those are taken from a different law report.
Right, and they should
It could hardly be, given that the ICR report starts at 752.
Yeah.
Right,
So the correct references are?
The correct reference is page 379 of our bundle, internal page 767E to H.
Thank you.
Thank you.
Very, very briefly on Kenton Griffiths, I would simply say that the correct analysis of Kenton Griffiths respectfully was provided by Lord Toulson in Michael at page 711 and paragraph 70. Paragraph 81.
Michael, paragraph?
81, page 711. At letter D, he said the Court of Appeal upheld the trial judge's finding of liability against the ambulance service. It would have been sufficient to hold that the acceptance of the doctor's request for an ambulance to come immediately gave rise to a duty of care. But Lord Wolfe, with whom the other members of the court agreed, went further.
I'm sorry, I've not got the page.
I apologise.
711.
711, thank you.
And it's the middle of that page at letter D. He went further. He held that the ambulance service, as part of the health service, should be regarded as providing services equivalent to those provided by hospitals, and not as providing services equivalent to those rendered by the police and fire services. Accordingly, the staff of the ambulance service owed a similar duty of care to that owed by doctors and nurses operating in the health service. And that we would submit as the correct understanding of the basis on which that case was decided. In short, therefore, we say there is no analogy in any of the cases cited in relation to this exception. And finally, I need to say something briefly about the firefighters. It wasn't relied upon in oral argument yesterday, but the appellant do in their written case at page 81. In paragraph 77b, argue that where an accident results in a multi-agency approach requiring police attendance, coordination and scene management rests with the police. Thus, as regards the fire service, since the police had taken overall control and responsibility for the accident scene, they took direction from the police as to the actions that they needed to undertake at the scene and as to when it would be appropriate for them to leave. First of all, I should say that point about the multi-agency approach is supported by a College of Policing document that was produced for the first time in this court. It's not pleaded. And I would submit that in any event, the fact that coordination and scene management rests with the police is not enough to find that the fire service were prevented. But more significantly, we need to look at what was pleaded in this case. And I apologise, I need to take your lordships to the separate document, the particulars of claim that's not in the bundle, because this is one of the missing pages. It's page 9 of that document, paragraph 58B.
What is the document called, the bundle called?
I think it's just called particulars of claim.
Yes, the particulars of claim document, thank you, because I've got that. And paragraph?
Paragraph 58B on page 9, my lord. There is a bare assertion that but for the attendance of the police, the fire service would in all probability have taken control and remained at the scene and ensured the safety of road users until the ice hazard was cleared. That assertion is not supported by any factual pleading. The only relevant pleading I would submit is at paragraph 40 on page 6. At or around the same time, that is the same time that the police left, the fire crew also left the scene, happy that Mr. Kendall had been taken to hospital and believing it safe to leave his car where it had come to rest. So the firefighters, when they left, knew that the police weren't staying. There was nothing stopping the fire service from staying. These pleadings don't provide any basis for the leading of evidence at trial that the fire service took directions from the police or were prevented from doing anything by the police. And indeed, no such evidence was produced in respect of the Summary Judgment Act application. I don't have time to take your lordships to them, but Mr. Thomas' statements are at page 217. They don't establish that there was a taking of direction by the firefighters from the police. At their highest, there's reference to a coordination of leaving. I therefore submit that if the claimant is successful under ground 1, that this ground adds nothing to the appellant's case. And unless I can assist further, those are my submissions.
Ms Davis, thank you very much. Mr Warner.
My Lord, turning then to the other of the exceptions, and I should have perhaps just mentioned what we say in our case about the nature of the exceptions. And it ties in, I think, with that discussion we've been having about the nature of the so-called prevent or interference exception, is that as we see it, and of course it's a matter for this court, what have been described as the exceptions to the omissions principle are really, in truth, convenient means of categorising or providing a taxonomy of situations where duties of care have been found. It would be wrong to read them like a statute and apply them as if they were rules themselves. They certainly relate to principles which can be teased out of existing case law, but that's how they should be approached. And we emphasise what this court said in Lord Reid said in this court in Robinson, and we set that out in our case at page 108, not proposing we turn it up, that where the existence or non-existence of a duty of care has been established, a consideration of justice and reasonableness forms part of the basis on which the law arrived at the relevant principles, and it's therefore unnecessary and inappropriate to reconsider whether the existence of the duty is fair, just and reasonable, subject to the possibility that this court may be invited to depart from established line of authority, nor a fortiori can justice and reasonableness constitute a basis for discarding established principles and deciding each case according to what the court may regard as its broader merits. And what we say Robinson has corrected by re-establishing the orthodoxy of the common law was the idea that one could just decide cases on a broad application of what one thought the justice was, which is what the Court of Appeal had done in Robinson. But one has to look closely at the analogous authorities and the principles which underpin them and decide the case in accordance with those. And that's why we see overlap in the exceptions. That's why we sometimes see Dorset Yacht, for instance, analysed as a creation of danger case because the Home Office brought the boys with a known propensity to escape onto the island and then didn't look after them. But also analysed as a control case. And that's why we say, too, that if a duty has been found not to exist in a particular factual situation, it's very unlikely that it's going to suddenly satisfy one of the other so-called exceptions. I know that assumption of responsibility is not being relied on as such, but since it is relevant to how the control exception is analysed, I would quite like to just briefly go to Ansell and McDermott, which is in the bundle at page E272.
3372.
272.
272.
Yeah. The facts of this case were, apart from the fact that Mr. Kendall doesn't exist in this case, it has very many similarities to ours because the police are put on notice of the fact that there's essentially a fuel slick, a diesel fuel on the road, and it's leaked from somebody's vehicle. And it was alleged that 2 police forces were involved, that they drove past this village, noticed the presence of the diesel, reported the matter to the Bedfordshire Highways Department, but then continued on their duties. One of the other police forces, that was the Bedfordshire Police, the other police force, Hertfordshire Police, had followed the trail until they came to the motorist with the leaking vehicle and found him. And it was alleged that the police should have done much more than that because, very tragically, the claimant's wife was killed when her vehicle skidded on the diesel fuel. And the issue was whether the police owed a duty of care. And the court held, as one sees at the holding, that the police were under no duty of care to protect road users from or to warn them of hazards discovered by the police while going about their duties on the highway. And there was, in the circumstances, no special relationship between the plaintiffs and the police, giving rise to an exceptional duty to prevent harm from the dangers created by others. And of course, as we have returned to orthodoxy, that point's enough to determine the case, although the court did go on to look at, in a Caparo light, as courts were doing at that time, the question of the policy considerations. And Lord Justice Beldam at page 282 having cited the Hill and Chief Constable and Caparo and Dickman. But he said at letter D, I approached the question of the existence of a duty of care in the present case with these considerations in mind. Firstly, as Lord Keith pointed out in Yuen Kun Yu and Attorney General of Hong Kong, there was clearly a special relationship between the prison officers and the owner of the yachts, so close and direct that a duty to take reasonable care to prevent damage to the yachts arose. That's clearly considering Dorset Yacht. But as the citation from the judgment of Dixon, Jay and Smith and Lures shows, it is exceptional to find in the law a duty to control another's actions to prevent harm to strangers. And when they are found, they arise from special relationships. When it is contended that such special relationships arise out of duties carried out in the performance of a public office, the court must have regard to the purpose and scope of the public duties, whether they are intended to confer benefits to a particular section of the public, e.g. investors or depositors, and whether such persons can reasonably place reliance. And then he set out concerns about the duty of care imposing upon a police potential liability of almost unlimited scope. Not only would the class of persons to whom the duty was owed be extensive, but the activities of police officers which might give rise to the existence of such a duty would be widespread. The constable on the beat who failed to notice a danger on the pavement, who noticed it but dismissed it as insufficiently serious to warrant his attention, the officer who searched for but failed to find property when he might have done, or the officer who misinterpreted a breathalyzer reading might all be said to come under a duty to anyone who could, or a liability to anyone who could show that they suffered injury or loss as a result of his failure. And it's also instructive just to look briefly at Sir John McGaw's judgment at page 283, which is very brief. And he referred to the fact that in Hill and the Chief Constable of West Yorkshire, it was held by the House of Lords that there was no cause of action against the defendants for alleged negligence in the conduct by the West Yorkshire Police of a criminal investigation. The facts which had to be hypothetically assumed for the purpose of the striking out application were that the police investigation of a series of murders had been carried out without a reasonable degree of care, that if such care had been exercised, the murderer would have been identified and arrested earlier than was in fact achieved, and that the result would have been that the plaintiff's daughter, the last victim, would not have been killed. It was accepted that, by common law, police officers owe to the general public, the public at large, a duty to enforce the criminal law, but was held that the duty was not a duty owed to individual members of the public. That being the position regarding criminal investigation by the police, where the duty owed to the general public rests exclusively on the police, I can see no valid reason for holding that a more extensive duty exists, a duty owed to individual members of the public, in respect of a sphere of public duty, where the primary duty, maintaining the safety of the highways, rests on public authorities other than the police. Turning then against that background to control, because the control exception was said by Lord Toulson and Michael, and it's at page 714 of the bundle. Paragraph 98, he talks of the rule, that's the rule about omissions, is not absolute. Apart from statutory exceptions, there are, of course, two well-recognised types of situation in which the common law may impose liability for a careless omission. The first is where D was in a position of control over T and should have foreseen the likelihood of T causing damage to somebody in close proximity if D failed to take reasonable care in the exercise of that control. The Dorset Yacht case is the classic example, and in that case, Lord Diplock set close limits to the scope of the liability. As Tipping J explained in Couch and Attorney General, this type of case requires careful analysis of two special relationships, the relationships between D and T and the relationship between D and C. I would not wish to comment on Tipping J's formulation of the criteria for establishing the necessary special relationship between D and C without further argument. It's unnecessary to do so in this case, since Miss Michael's murderer was not under the control of the police, and therefore there is no question of liability under this exception. And the points we make in relation to this are, firstly, in capital and counties, the courts have held that the police do not assume a duty to the owner of premises by their attendant, the fire brigade do not assume a duty to owner of premises by attendance at and taking control of a fire. Claimants' proposed distinction between controlling operations and controlling the scene, we submit, is a clearly bad one, because the former necessarily includes the latter, as we see in the fire brigade case where the people on site were ordered out. Secondly, whatever control the police had of the scene, and we set out on our case how it's in fact alleged that the police didn't even inspect the ice, but whatever control they had of the scene during their attendance at Mr. Kendall's accident, they were in no longer control of it by the time of Mr. Tindall's. And we rely on, and I've set them out in our case, the principles set out in Shepherd and East Glossop about you don't have a duty to carry on putting light. If you don't, just because you've done it, doesn't mean you're under a continuing duty to do it. East Suffolk, where it was accepted that the defendants couldn't be liable if, having started operations, they then suddenly decided to abandon them. And Gorringe, where it was held that the fact that the local authority or the highway authority in that case had previously put a warning sign in place on the road didn't mean that they were under a duty to keep one there. So those are the submissions we submit in relation to the control side of that equation. I don't think it's necessary for the court to decide whether or not the control exception only applies to people and animals. But I would point out that, interestingly, the Carmarthenshire case, which my learned friend referred to, which was mentioned in Dorset Yacht, the case where the child escapes from the school, setting aside the fact that that's a case where the child was in and should have been in the custody of the school at the time the event happened. The House of Lords reasoned that case by analogy with the duty that people who own animals or have possession of animals have to keep them under control. That's how they reasoned it. So it was like having something escape from your premises. And then as for the relationship with the second relationship, which Lord Toulson identifies, we refer to, and we've set out in our case, the passages Gorringe, where it was said that the lady who had the crash at the Dangerous Crest was no different relationship with the highway authority than any other person who drove down that section of the road. Ansell, where the same point was made about the gentleman who crashed on the and sadly lost his life on ice, the local authority having, or the highway authority in that case, by reason of administrative foul-up, not having iced it that night. And Sandhar, which we looked at briefly, but not on the fact. Sorry, Ansell. Sorry, I've confused those two. Ansell is the case we've just looked at about the diesel spill. It was Sandhar was the case about the ice, which caused the crash. And we do submit, if you go to, we do submit, it would be a remarkable result if the police in this case were to be held to have come under a common law duty of care by reason of control, by reason of their 13 minutes attendance at Mr. Kendall's accident, when the authorities clearly demonstrate that the highway authority, which actually owns and has responsibility for the highway, does not, even in a case like Stoven, where Lord Nichols described the judge as being, Lord Nichols described the bank on the bend in question as being exceptionally dangerous, and indeed there had already been several accidents at it. And we submit, actually, it would be all the more remarkable since if the police owed a duty in relation to do something about the ice, in this case, a common law, given that the common law is that even a highway authority owes no duty of care at common law to protect motorists from snow and ice. And we've referred to that in our case at paragraphs 8 to 10 on page 96, where we refer to Goods and East Sussex. The case involved a question as to whether Section 41 of the Highways Act, which creates a private law duty on a highway authority to maintain the highway, included an obligation on the highway authority to make the roads safe from ice and snow. And that involved the House of Lords looking at whether or not the duty which was enacted in Section 41, which was the old common law in duty, had extended in its scope to protecting, keeping the highway free and safe for passage from ice and snow. And the House of Lords held that it did not, and that there had been no such common law duty on the highway authority. And of course, as is well known, following Goods, Parliament amended the Highways Act, as we say at paragraph 9, to introduce a duty actionable at private law on a highway authority as so far as reasonably practicable to ensure safe passage along a highway is not endangered by ice and snow. There's no such statutory duty on the police, and so we do submit it would be a rather extraordinary result if, on the facts of this case, the police came under such a duty in circumstances where at common law the highway authority wouldn't. And then finally, in relation to, I have not mentioned Gibson and Orr, my learned friends haven't mentioned it, but we submit in relation to Gibson and Orr, whether or not it's the law of Scotland, I'm not going to be so bold as to comment on. And there is reference in the case to the fact that a highway authority's duty in Scotland is perhaps more extensive than is recognised in the common law in England. And that's, in any event...
It wasn't a case concerning the Highways Authority, was it?
No.
No. But
but that was part of the reasoning.
It was a reasoning based on Caparo.
Yes. And indeed, when one looks at the cases cited in the law report, it's quite striking that Stoven wasn't cited, East Suffolk wasn't cited, Shepherd and Glossop wasn't cited. And then, of course, we've had the further elucidation from this court as to the correct principles. But Lord Justice Stuart Smith, in our submission, demonstrates convincingly why that case is not the law of England. In relation to status, we've set out the relevant passages in our case, and I can't do better than refer to my Lord Burroughs' summation with Lord Stevens in HXA, and it's page 116 of our case. We've set it out. Page 116 of the bundle, paragraph 69 of our case. And my lords said one has to be very careful not to slide back to resting the duty of care and breach at common law on the mere fact that the public authority had statutory duties towards and powers in respect of the claimant. In our view, some of the submissions made by counsel on behalf of HXA and YXA fell into this trap. That is, she sometimes relied on there being a statutory duty on the local authority to safeguard children in need as the very reason why there must be a duty of care to such children. As we have just indicated, what is required, which the courts, perhaps unhelpfully, have sometimes referred to, see paragraph 61 and so forth, as the something more or something else, is that there would have been a duty of care owed because, for example, there is an assumption of responsibility had the public authority been a private individual. I do submit that there is some danger in the analysis. Well, they're the police. Everybody would expect that they're the police. There's a danger of slipping into that trap. My lords and lady, those are my submissions, unless there's any particular issue I can help you with.
Mr. Warnock, thank you very much. Mr. Byrne.
My lords, my lady. Could I start first by reminding your lordships, I'm sorry if that does not, I don't mean that in a disrespectful way at all, but what, certainly speaking for myself, I did not even begin to appreciate that we would need in the bundle were the basic tests about the dangers of striking out developing areas of the law on hypothetical fact. So I'd first of all like to go back to striking out 101 principles. I'm afraid, could I just read you the relevant section in the White Book? It's very short, and then I'll give you the references to some of the material that are in the bundle, but the other main extremely well-known House of Lords, and I think possibly Supreme Court cases from the late 90s and early 2000s that set it all out.
Three Rivers, no doubt.
And
Three Rivers, no doubt, going through your...
Oh, well, I don't have that one, but I'm sure it's there as well. I mean, it's all over the place. And what we are doing here, I mean, I'll read it in a moment, is we cannot have a mini trial on paper where there is uncertainty, ambiguity, and, Well, it's a quagmire, potentially, and particularly in a case of not only the legal importance, but the outcome is obvious. 2 men died. Another jury point, I withdraw it. Right, White Book, page 95, CPR 3.4.2. An application to strike out should not be granted unless the court is certain that the claim is bound to fail. Hughes against Colin Richards, 2004, EWCA Civ 266. And then there's a note in the editorial section of the White Book. Relevant area of law subject to some uncertainty and developing, and it was highly desirable that the facts should be found so that any further developments of the law should be on the basis of actual, not hypothetical fact. So that's what the White Book tells us.
Am I right that it's not only strikeout but summary judgment also here?
Correct, but there have also been, I think, many statements that in practice, in this type of case, the test is effectively the same. And it would be very surprising if you decided you weren't going to strike it out, but you were going to give him summary judgment, I'd say. Anyway, I'll go into the facts in a moment. I want to do the test first, and then I'll look at the facts. Now, Barrett and Enfield, 2001, 2 appeal cases, 550 at 557 E to G. And there, Lord Brown Wilkinson said, in an area of the law which was uncertain and developing, such as the circumstances in which a person can be held liable in negligence for the exercise of a statutory duty or power, it is not normally appropriate to strike out. In my judgment, it is of great importance that such development should be on the basis of actual facts found at trial, not on hypothetical facts assumed, possibly wrongly, to be true for the purpose of the strikeout. And that was based upon the famous mistake in relation to the Educational Psychology Service being something that was open to the public, like a hospital. Now, we don't necessarily have that sort of thing here, but we do have real uncertainty on the foreseeability point, which I'll go into factually. And then Lord Slynn in Waters, 2000, 1 Weekly Law Reports 1607, 1613H to 1614A. It's very important to bear in mind what was said in Exon Bedfordshire, in Barrett, and in W and Essex, as to the need for caution in striking out on the basis of assumed fact in an area where the law is developing, as in negligence claims in relation to public authorities. And then we get Lord Bingham in East Berkshire, 2005, 2 Weekly Law Reports, saying exactly the same thing, but using the language contentious and developing area of the law which needs a fuller factual inquiry. Now, if that is the case, and I'm sure that will be uncontroversial. One has to then look at just two examples. Capital and Counties and Kent and Griffiths are cases where there were full trials. Of course, I accept pool HXA cases like that, where there's no basis. One of the big problems in the child care cases was the lack of a pleaded basis.
Michael, against the Chief Constable of South Wales Police, was also a summary judgment case.
Correct.
There was no basis for the negligence claim to
yes.
proceed.
Correct. No, that's right. No, I don't deny at all that there are examples where, of course, there are strikeouts. Of course, that's right. But it's the need for real caution. Now, if I could now go to the facts to try to establish that the police knew or ought to have known about the status of Mr. Kendall as a volunteer rescuer.
And you accept that that's necessary, do you?
Yeah, we've accepted that, I think, in our submissions, yeah. Waving vigorously, I'm going to try to avoid having to take you back to the documents, because I think I've referred to all of them, and you've got the references, which I will endeavour to repeat. So waving is admitted as a fact, vigorous waving. And we see that at paragraph 1 of the SFI. There is extra material on the fact that there's waving. It's pleaded at paragraph 22, which you've got in terms of the additional document. Kendall's third witness statement, paragraph 9, at 222 of the bundle. Just get rid of that.
That's all well before the police arrive.
Yeah.
I don't think any of this it would be questioned. I mean, no one's denying that he did certain things in relation to the van. The question is, what did the police know or should have known?
But you have to look at the whole process.
Yes, okay.
In order to ask yourself then, given what they know and what they've accepted, whether in terms of the strikeout test, that it is you can be certain that this case will not, that a trial will not expose elements that will enable the claimants to establish the duty and to establish their breach. So waving is admitted as a fact, as I say. So So there's no doubt about the van slowing. And there's also no doubt that it's admitted, this is paragraph 2 of the SFI, core volume 42, that he told the call handler that he was waving cars down. So the call handler knew that he was a rescuer.
No, that's not right. That is a misrepresentation. He flagged down a van.
Well,
I mean,
all right.
You can't rewrite the statement of facts and issues, Mr. Bowen.
Well, I'm not trying to do that, but what Mr. Warnock can't do is make inferences, which I think he did on this point, that he was seeking or query whether he was seeking to vigorously wave, not in order to protect both himself from other cars sliding off, but other drivers. And what he was actually doing was trying to stop somebody because he was injured. I mean, that is effectively what Mr. Warnock...
He wasn't suggesting anything about the actual intention of Mr. Kendall, but only what the operator would reasonably have understood from what was allegedly said.
Yeah. Well, let's just go on. So the police, having admitted that the call handler knew he was we would say, a reasonable assumption that if they are having, as we say, she's receiving information that he's waving, that's admitted. Well, the lady shakes her head, but I'm going to take you to the transcript in a moment and point out errors in the transcript, possibly missing, there is, I don't know whether you've spotted, or no, somebody did spot yesterday, and we've spotted 3 more, reversals of who was saying what.
Yes, we saw that.
So, yeah, and there are 3 others in relation to that. In fact, why don't I go to that point immediately?
But the context makes it clear who's speaking. We can quite easily tell who's speaking.
What's the context? Hang on. Just forgive me a moment. So. Yes, CV202. So if you go to that. And you see there, this is the page where there are the errors in terms of who is speaking. Can I take your date of birth, please? And then he gives it. 66, in 1966. And are you stuck on the side of the road? Or are you obviously, I can hear other vehicles going? And then there is what we submit is a curious reply. They're just driving past, they're not stopping. It's 4 o'clock in the morning in it, they're not going to stop. Now, we know from the witness statement drafted that at paragraph paragraph 10, as soon as the van passed, I decided...
Page number?
Oh, sorry, forgive me, 222 again. I could not decide whether to dial 999, so I decided for some reason to dial 101. I explained to the controller the facts of the accident, that my back and chest were hurting, that I had tried to flag the van down, but that it had failed to stop. Few other vehicles passed by whilst I was on this call, but I didn't try to flag them down as I was engaged on the phone. And that, of course, is another admitted fact in the SFI. That the only reason he wasn't flagging when they came, which is significant, and I think that's one of the questions Milady asked Mr. Warnock yesterday about, well, what have you been flagging when you arrived? The reason he wasn't flagging was simply because he was calling the police. And that's admitted. But we see here, paragraph 10, what he's saying, and he then says, had I not called the police, I would have continued my attempts to stop the traffic due to the dangerous state of the road. And then go back to 202. They're just driving past, they're not stopping, it's 4 o'clock. Now, I can see there is a reference to hearing other vehicles, but that could be because of a slight difficulty that she had hearing his date of birth. I'm suggesting that there is some missing speech there related...
So what? I mean, nothing else... It's 10 years now since the accident occurred. It's not as though some new rabbit is going to come out of the hat and turn up now that isn't already in the evidence. If he claims to remember something that he said that he hasn't put in his witness statement, nobody is going to be able to rely on that 10 years after the event.
Right. Okay.
We've got everything we're going to get, well, in reality.
Well, I'm not abandoning the point I'm pushing on you, but even if on what we've got enough. Now, just please bear with me on this. So, waving admitted as a fact, admitted that he told the call handler he was waving cars down, the conversation, the point I just made, to which we say it was pretty obvious that he was trying to assist others. The other evidence in relation to waving and communicating to the call handler, and this I suppose is subject to the point Lord Leggatt just made, CV 209 and CV 212, third paragraph, again, ambiguity as to what was happening in the call. Look at 209. That's the first witness statement. Foot of the page. I then rang the police from my mobile at about 4:30 to 4:45. A few cars were going past me on the road, and I tried to wave somebody down, but no one stopped. I had pain in both my back and chest.
That's not saying I was trying to wave everybody down. He just get somebody to stop, presumably to come and help him.
Well,
but anyway, you only have a limited amount of time.
Yeah,
and the court is giving you your full half hour. I think you'd be better served to give us all the references which you say amount to enough.
Yeah,
we can read them after the...
All right, I'm grateful. All right, so CV 209, CV 212, third paragraph, yes. Ambiguous, CV 206. That material was put together not for the purposes of the structure or the bones of a duty of care argument. The first was a criminal, potentially, Section 9 statement. The second was the IPCC looking into disciplinary issues. And the first time that he was asked a relevant question, we get the answer in the third witness statement. So then, I say all that establishes that the officers are going to have constructive knowledge or sort of organisational responsibility if the call handler knew enough. They therefore knew or ought to have known when they attended that he had been involved in what we call a rescue operation. The only reason that he wasn't waiving, point I've already made, is because of the call. And we say that Mr. Warnock can't effectively have his cake and eat it, which is what we say the concessions in the SFI amount to. So paragraph 1, he was waiving, concession in relation to what the call handler was told, and that he stopped only because he was making the call. And all of that, enough of that is pleaded. Conversations then happened, of course, between Mr. Kendall and the officers, and we don't have much material on that. That material on that, assuming the witnesses are still alive, can, of course, it's perfectly possible that something could come out in relation to that. Now,
you mentioned earlier, and I don't know whether you were suggesting that this was the test, that we have to be certain that a trial will not resolve these difficulties.
Correct.
That you're saying is the test, is it? We have to be certain that something won't be thrown up.
Well, for summary judgment, there must be no realistic prospect, which is not quite the same. If there's a fanciful prospect, that isn't. It won't be enough.
Sorry. Yes, correct. But the certainty relates to you've got to be certain that the claim will fail. It's a very high threshold.
Well, that's not what it says in summary judgment. It says no realistic prospect of success, and that's not the same as being certain it will fail. It's quite a high test, but it...
of course, Supreme Court, you know the test. I'm not going to even begin to try to... I've given you the relevant references. And the test, I say, is set out there in the White Book as per the Colin Richards case. As an alternative, or additional to, or an alternative, we say also that there was a displacement of the fire brigade as a putative rescuer. And that is pleaded, contrary to what my learned friend submitted. There is enough in the pleading. And of course, it's also non-controversial that on a strikeout, if the court feels that otherwise there is enough, but there's a problem with the pleading, an opportunity should be given to amend the pleading. And that's a very well-established principle. So one goes to the particulars of claim. Paragraph 58. And at 58b, further, but for the attendance of the police,
the fire service would in all probability have taken control and remained at the scene and ensured the safety of road users until the ice hazard was cleared. And then you were taken to paragraph 40. At or around the same time, the fire crew also left the scene, happy that Mr. Kendall had been taken to hospital, believing it safe to leave his car where it had come to rest. So given the gross negligence that we know about, and you've got the evidence of Mr. Thames at 217 to 219, there is, we say, enough there for your lordships to allow this case through on the basis that there was a displacement of the fire brigade, as well as, or in addition to, the displacement of Mr. Kendall. Now, if that is the case, you can't, we say, strike it out. Can I move on? Just bear with me a moment. Just quickly on incrementalism and Caparo. CV, right, the broad submission. Lord Burrows particularly, I think, yesterday talked in terms of whether or not there was a case that established, I think that was in relation to interference, I think. Oh, no, sorry, it was in relation to both, I think.
Yeah, was.
When we were having discussions about making matters worse and the extension of the principles that one sees in capital and counties and also Kent and Griffiths, that is there anything else? He said, is there another case? Well, I've reminded myself about what Lord Toulson said at paragraph 102 of Michael, and also what Lord Reed, and could we just have a quick look at that? CV.
Do be careful, you've got 5 minutes left.
Right, okay, well, we won't look at it.
Give us the references.
All right, okay. Yeah. CV 715, Robinson, paragraph 26 to 27, CV 878, 746E, to the top of 879. There, Lord Reed is talking about the incremental process and the application of principles as opposed to case law. So there are two points. One is that in relation to the interference issues, they are more in Caparo territory, because we discovered some American cases. You'll see that in the Bagshot 1999 article, the one about the sailor and the broken leg, being the man who would have drowned anyway in the sea. And there's the department store case, Zelenko, and a few others. That is something that at a trial could be looked at and then in relation to policy. In terms of incrementalism and just moving analogously between areas, that is making matters worse if we need that. But of course, we say that we have enough as we stand. Lady Dorian, slightly separate point, Lady Dorian's CV 1061 talks about taking and relinquishing control can be seen as making matters worse. And then in relation to the exceptions, they're referred to as principles in Great Lakes by Lord Burrows. We haven't abandoned AOR in the sense that it's swept up, and we talk about assumption of responsibility in relation to control and status, point I think that's been taken by the court. They're not in silos, they merge. And I'd remind you about what Lord Keith said in Caparo about in the law of tort, it's very often that many different phrases and labels are used to express the same principles. Yeah. I think we've got a couple of minutes left, I think.
We do?
I don't know. Yeah, I think 2 or 3 minutes, and there's 3 minutes left.
Well, my Lord and Lady, I'm just very briefly addressing you in reply on the issue of control. 2 very short initial points. First point, just to for your note, I think and from Mr. Warner referred to the time at the accident as being 13 minutes. It was, of course, 23 minutes rather than 13 minutes. On the point as to the other cases cited, Ansell, Sandar, etc., I did address them in my submissions yesterday, but of course the key distinction between the current case and in those cases is that in none of those cases did the public authorities have control of the relevant thing when it constituted a danger, whereas of course in our case we say that the police had control of the scene when the ice was there, and therefore it constituted a danger. And in the same way, and that explains, of course, why it is not an extraordinary result for the police to be found potentially responsible in this case and not the Highways Agency, because, of course, it's on the facts of this case, the Highways Agency did not have actual control of the scene with the ice at the relevant time. The only other point to address in terms of control is addressing Lord Legate's concerns yesterday as to the moral underpinnings for liability where control is taken and relinquished. I'll just give you the reference to Professor Sandy Steele's 2019 article, which is at 1343 of the bundle. And at that page is a citation from Ripstein, looking at control cases, and says, where it is said, cases in which control is invoked can be explained as cases where one person imposes a foreseeable risk of physical harm on another. And Professor Steele remarks that this thus collapses control into a creation of risk category type of case. So one explanation, therefore, potentially for the moral underpinnings for liability where control is taken and relinquished is as follows: where the defendant has exercised control over a danger, in this instance the ice, they have effectively ended or negated that danger. As such, it could be said the danger ceases to exist.
And it's then reinstated.
Indeed, exactly. The relinquishment of control could therefore be construed as a creation of the fresh danger, and there is no dispute, I don't think, my understanding, on the authorities that there is it's a legal obligation, but also moral underpinnings of an obligation to protect the reasonably foreseeable victims of a fresh danger. And so that, we say, is a potential explanation for the moral underpinnings of that aspect of the case. My Lords and Ladies, unless I can assist you further, that's what I have to say on control.
Thank you very much, Mr. Miller.
I'll just give you 2 more references, on the strikeout. It's very quick.
You're into injury time, but we'll take your references.
All right, yeah, I'm not going to say anything else. Couch 1097, 30 to 31 paragraphs, and then Lord Reed in the Inner House in Mitchell, CV 1197, paragraph 133.
119.
1197. 133.
Paragraph 133. Yeah. Thank you very much.
And thank you for the extra 10 minutes.
Well, you were just claiming what we lost at the late start. So it wasn't extra. But thank you very much, Mr. Byrne, and Council for their submissions in this interesting case, and they're grateful to those who sit behind Council and have assisted them in the preparation of the case and the papers. The court will take time to consider its judgment in this case.
Thank you.